Good day, colleagues. My name's John Botha, the Joint CEO of Global Business Solutions, and I'm very proud to be doing this series on harassment in collaboration with MISA and the IADF. Colleagues, harassment in any form is not acceptable, not at the workplace, not outside the workplace, not at any time. You need to stand strong. Don't be adaptive. Don't submit to this. Stand strong and take action, because we cannot afford to have toxic workplaces. It destroys families, it destroys careers, and it destroys individuals. Toxic workplaces, colleagues, have put South Africa ranked 69th out of 72 countries in terms of mental well-being at work. We need leaders who care for their staff, and we need managers who take control. But we cannot just have managers. We need to look after our staff. So we've got many managers but few leaders, and we need to ensure that our leaders are aware and are capacitated in this regard, and that you are capacitated so that you do not tolerate any form of toxicity, including harassment. So, colleagues, let's take a look. In this video today, we're going to take a look at employer obligations. Employers don't only deal with things once they've happened, they've got a legal obligation to be proactive and to put steps in place. Secondly, we're going to talk about investigating claims of harassment. What about anonymous claims? What about victims of harassment? What are the options? How do you approach dealing with harassment? Is it through a grievance procedure or otherwise? We'll take a look at data laws. In other words, how does the POPI Act, for example, impact the investigation of these particular instances? Employer liabilities, and then maybe one or two cases. But I want to be very clear, colleagues, if you take a look at the left-hand side, Section 60 of the Employment Equity Act actually says that if companies do not take steps to prevent and to deal with harassment expediently, then it's almost as if the company has harassed that employee. In law, we call it vicarious liability. What it means is the company then is responsible vicariously for the acts of the employee who is the perpetrator of harassment. And you'll see it's highlighted there in red in the third paragraph. It said, if the employer fails to take the necessary steps, and it's proved that the employee, in other words, the perpetrator, has contravened the relevant provision, the employer must be deemed to have contravened it. But it doesn't stop there. It says, despite this, an employer is not liable if the employer can prove that it did all that is reasonably possible to prevent this. Now, on the right-hand side, I've given you a checklist of what the courts would look for. So the company would have to say, listen, we've got a policy on zero tolerance on harassment that's been signed by the CEO and communicated. Secondly, we've got a disciplinary grievance procedure. We've done awareness creation. We've looked at all the forms of harassment, and we've done awareness training of the impact it has on individuals and the company and what the consequences are. We've done a harassment risk assessment, and we've trained people on how to master themselves. Some people, colleagues, need to become more self-aware so that they can reflect before they react or respond. You can't react. Lots of people end up in trouble because their amygdala hijacks their rational thinking, and they just act in the spur of the moment, and they don't think of the consequences. So part of this is to capacitate people in personal self-regulation. Yes, some people are just malicious and intentional, but there are some people who have a more propensity from their personality point of view to think they're very funny and to crack a joke on race or gender or religion. So organizations have to investigate every single claim of harassment. Social and ethics committees, employment equity committees, and organizations' procedures would require this from a governance point of view because of the consequences on organizations of getting this wrong. Firstly, the organizational culture must be one that is healthy. You can't have a toxic workplace culture in the world we live in because it reduces productivity, creativity, and innovation, and harassment undermines employees' self-worth and confidence. You can imagine the impact that that has on performance. More importantly, almost from a legal point of view, is employers have an obligation to investigate every claim or allegation of harassment, even anonymous ones. What I do want to say, though, is companies often say to me, but John, what if employees use this as a lever to get at their managers or at other colleagues, and they're malicious? Well, that in itself would be a problem because remember, generally speaking, if you make an allegation, you do need to back it up, but the company has the obligation to assist you in these investigations. Now, if, for example, you had been the victim of harassment, the Code of Practice on Harassment gives you two options. You can go to your line manager or your human resources department or whoever it is and say, listen, I don't want to formalize this process. I just want you to go and talk to John because he's got this habit of, staring at me, or he's got this habit of telling racist or sexist jokes. And I just want you to speak to him about it. If he changes his ways, then it's cool. Other times, employees feel they want to formalize this, which means you go through a formal grievance process. The point I'm trying to make is that even though an employee can initially choose to informalize it, if the offense is of such gravity, in other words, if it is sexual assault or rape or like gross misconduct in the context of maybe sexual offenses, colleagues, that is not an option. You have to formalize those particular instances. Well, someone says, John, what about data privacy laws? These are very damaging investigations, and how do we deal with it? Well, colleagues, the POPI Act specifically says that you are allowed to process personal information, which would include witness statements, photographs, videos. You're allowed to process that if it's part of the process of pursuing your rights at law. So therefore, the employee's right to privacy takes the back seat to the right of the company and the alleged aggrieved employee who's been a victim of harassment. So companies can then gather evidence of all sorts, maybe access an employee's laptop records, cell phone records, because it's part of this investigation, and the POPI Act specifically allows that. Also, the POPI Act allows it, and you remember, harassment is also a criminal offense, potentially under the Hate Speech Bill, and also, colleagues, under the Cybercrimes Act. What you do have to do, though, is in the process of investigation, you've got to be extremely confidential, colleagues, because the reality is that these are damaging allegations. The Cybercrimes Act, as I said, also results in fines or penalties of up to 5 years. And I really believe organizations should be telling their staff that if they do get this wrong, they face significant sanctions, and it's just not worthwhile nor acceptable. We have been doing harassment risk assessments for companies over the last 3 years. And what we do is we take the 18 forms of harassment and we issue a survey across organizations. And what we've been able to do is to build up, let's call it a top 18 list, but it starts in terms of the most highest ranked is the most prevalent form of harassment, and then it works down to the lesser forms of harassment. And isn't it very insightful, colleagues, to see that obscure forms of harassment? I mean, we're all aware of race and sex and, those types of harassment, but what about ostracism, humiliating people in front of their colleagues, sarcasm, constant personal criticism or emotional abuse? These are all taking place at workplaces where organizations should not be doing this. It's not acceptable in terms of the code. It's not acceptable anywhere, but it's happening. And then further down, we have abusive language. And some companies say, John, we're in construction, man. We are a rough bunch of people. Yeah, you can be rough, but don't use abusive language directed towards individuals. It's not acceptable. And colleagues, then further down, you'll see things like racism and sexual harassment and violence. So your organization is required under the Code of Practice to do a harassment risk assessment so that it can be preventative and proactive in identifying which departments, which levels are people more prone to harassment. And interestingly, in our results, we do find overall that women are more vulnerable in terms of harassment, and also certain race groups. Well, in conclusion, I want to just share with you that in terms of human dignity, the requirements in organizations is to treat everybody with equality. We all have got equal worth. Your self-worth is not your net worth in the bank or your status. You deserve to be treated with respect. You deserve to be treated as an individual. We're not all in the same boat. You need empathy from your leaders. You need empathy from your managers, rather than for them to use that against you. Especially in the world we live in, colleagues, it is extremely, extremely important to care for your staff so that when they go to work, they can focus and feel valued and belonging. Well, I hope you enjoyed this video, and I wish you all the best. Goodbye.